Hey guys, it's Kathy. How are you guys doing? I'm feeling good today. It's a good day. And I feel like stirring the pot a bit today. Let's do this. Let's. I was thinking about it. I was watching this court case and it was so funny. And I was laughing so much. And I thought, man, I'm going to show this. I'm absolutely going to show this, but I'm going to have to mute myself because, and it's just a small percentage. They're like, oh man, if I have to hear your voice again, it'll be too soon. And this one guy commented like 5 times yesterday. Shut up, stop talking. Shut up, stop talking. So let's weed these people out. Instead of muting my microphone, I'm going to weed these people out. And I'm going to play this clip, but I'm not going to mute my microphone at all. Because, we're not married. You guys and me, we're not married. So I don't see why only one of us gets to be satisfied during these clips. So we can both be satisfied together. I'm going to leave my mic unmuted for this first clip, and when I laugh, you'll hear. Hopefully, you'll still be able to hear the clip because it's very, very funny. Oh man, yeah, I have some good ones today. I do. We're gonna have a fun time. All right, let's get started. Here we go. Don't worry, they're coming.
20 CL1 2402 F6 177 State of Indiana versus Greg M. Cisnicki. Am I saying that right?
Your Honor.
Okay, so here's the deal. If you want to talk when I'm talking, I can't hear you. You can't possibly hear me. You give me your name again when I'm not talking. Go.
Oh, okay. It's Chesnitsky or Cesnicki is easier. Greg Cesnicki.
Cesnicki it is. Raise your right hand, sir. Do you swear or affirm under the pains and penalties of perjury that the testimony you're about to give will be the truth?
I do, Your Honor.
State your name.
Greg Cesnicki.
Thank you. What's your date of birth?
5/10/49, Your Honor.
Show defendant appears in person as a self-represented litigant.
5/10/49.
State of Indiana, in court by Deputy Prosecuting Attorneys Robert Swaby and Kathleen Clays. Sir, you're in court for an initial hearing as a result of the state of Indiana having charged you with count 1, battery against a public safety official, a level 6 felony, and count 2, resisting law enforcement, a class A misdemeanor. Count 1 reads as follows. The affidavit, the probable cause affidavit filed herewith swears that on or about February 1, 2024 at the County of Elkhart, State of Indiana, when Greg M. Cisnicki did knowingly touch another person, to wit, Officer Kyle Maycumber of the Elkhart Police Department, a public safety official, engaged in the execution of his official duty in a rude, insolent, or angry manner, all of which is contrary to the form of Indiana Code, Section 3542(2)(1)(c)(1) and E2, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. Count 2, resisting law enforcement, a class A misdemeanor, reads as follows. The affidavit, the probable cause affidavit filed herewith swears that on or about February 1, 2024, at the County of Elkhart, State of Indiana, when Greg M. Cisnicki did knowingly, forcibly resist, obstruct, or interfere with a law enforcement officer or a person assisting the officer, to wit, Officer Kyle Maycumber of the Elkhart Police Department, while the officer was lawfully engaged in the execution of the officer's duties, all of which is contrary to the form of Indiana Code 35-44131A1, contrary to the form of the statute in such cases made and provided, and against the peace and dignity of the state of Indiana. I will enter a preliminary plea of not guilty for you at this time. The penalty for a level 6 felony is an advisory prison term of 1 year. It can be increased to 2.5 years for aggravating circumstances or reduced to 1.5 year for mitigating circumstances, and you can be fined up to $10,000. The penalty for a Class A misdemeanor is up to 1 year in jail and up to a $5,000 fine. Sir, did you hear the rights that I read to the other people who were here on preliminary or for initial hearings?
That they've been there for 5 hours. This is 5 hours into this docket. Mr. Seznicki has been there for 5 hours and has heard all the other cases.
No.
You didn't hear him. You've been seated here all morning, so you didn't hear him.
It's stuffy.
You have the right to a public and speedy trial by jury. You cannot be compelled to make any statement or testify against yourself in any hearing or trial, but you have the legal right to remain silent. Anything that you do say can be used against you. You have the right to face all witnesses against you and to see, hear, question, and cross-examine them. You have the right to retain an attorney to represent you, and if you intend to retain your own attorney, you must do so within 20 days from today, since there are deadlines for filing certain motions and raising certain defenses. If those deadlines are missed, the legal issues and defenses that could have been raised will be waived. If you're unable to afford an attorney, you have the right to have an attorney appointed to represent you at no expense to you. Do you have adequate funds to retain your own attorney?
Yes, I do.
Who are you going to hire?
I can't think that it's Bowling and something. The other one's a judge in Elkhart. I'm thinking of going over there. I have to first of all see if, Your Honor, if he would take me.
Take you?
Yeah, I have to find out if you'll, you know what I mean, take me as a client, because I have
I'm not going to take you as a client. I'm the judge.
you asked me who the attorney I want to get.
Yeah, you don't know. You think you're going to hire Alex Bowling, but you don't know him. That's what I got out of all that.
You come to me when you have a big problem. I'm sorry, but I'm not. I have no attorney at this time.
So your attorney status conference is going to be February 15, 2024 at 8:30 a.m.
February 15,
2024, next week. Your pretrial conference is going to be February 28, 2024 at 8:30 o'clock a.m.
Oh, 8:35 p.m. What was the first one on the 15th? Can't hear.
The first one was February 15, 2024 at 8:30 a.m.
8:30 a.m.
Let me give you a hint. They're all at 8:30 a.m. Hey, are you listening? They're all at 8:30 a.m.
And they have
Can
been
you hear
for
me?
5 hours.
Yes, the 15th.
And the 28th.
Oh, a.m., not p.m. Okay.
Your omnibus date is April 4, 2024.
Okay.
Your trial status conference is May 9, 2024 at 8:30 o'clock a.m.
8:30 o'clock.
8 o'clock a.m.
8:30 o'clock a.m. Your jury trial is scheduled for June 3, 2024 at 8:30 o'clock a.m. Sir, do you acknowledge on the record that your case is scheduled for jury trial June 3, 2024 at 8:30 o'clock a.m.?
Okay, I got that.
Sir, do you acknowledge on the record that your case is scheduled for jury trial June 3, 2024 at 8:30 a.m.? That's a yes, I do, a no, I don't. Which one is it?
Yes, I do.
You understand if you don't show up for that jury trial, the court's gonna hold the jury trial without you.
Okay.
Not okay. Yes, I understand.
sir.
No, I don't.
Yes.
Cause coming on for initial hearing. Defendant appears in person as a self-represented litigant. State of Indiana appears by Deputy Prosecuting Attorneys Robert Swaby and Kathleen Clays. Court conducts initial hearing. Court schedules attorney status conference for February 15, 2024 at 8:30 o'clock a.m. Court schedules pretrial conference for February 28, 2024 at 8:30 o'clock a.m. Court schedules ominous date for April 4, 2024. Court schedules trial status conference for May 9, 2024 at 8:30 o'clock a.m. Court schedules this case for jury trial June 3, 2024 at 8:30 o'clock a.m. Defendant acknowledges jury trial setting on the record. It is so ordered. You're all done. Thank you.
Thank you so much.
Your Honor, where will this court hearing be? Here or in Elkhart?
That's an excellent question. It will be here because I don't go to Elkhart. Whatever would make you think I did.
This is new to me, Your Honor.
Get an attorney. Go get Mr. Bowling and get him to represent you. You need help. Get an attorney.
You need help. You need help. Oh my goodness. And there he goes. He made it. He made it out the door, and I made it through that clip. I think I have another real short one that is similar. I mean, it's like just a couple seconds long. I think this is it. I'm going to try it. If this isn't it, then I'll go to the next one.
That's okay.
This is it.
Right, I'll find that you are indigent and will appoint the Lake County Public Defender's Office. How far are we setting the south end, Mr. Fadling?
Your Honor, I would ask for 30 days.
Right, that's March 28th. So Mr. Harris, your order to return to court on March 28th at 9:15. There's a phone number on the card you're going to get. Don't call today because they won't know they've been appointed yet, but that's the number for the Public Defender's Office. You can call that number and speak to your attorney, and then we'll see both of you, your attorney and you, back on March 28th. Okay?
So I'll call today?
No, sir, don't call today. They won't know they've been appointed yet. Call after today. Okay?
Okay, thank you.
All right, and that will be.
These people have got to stop. They have to stop. They have to listen. You know, we'll do one more. We'll do one more like this, where I'm going to talk a bit because it's funny as heck. So, if you don't know how to bifurcate, you need a lawyer. Just always remember that. I learned a new word today. Bifurcate. And we're all going to learn this word together, although some of you probably already know it. I think I did it once, but that was when I was in college and I was experimenting, so it doesn't count. But here we go. Let's look.
Where do I need to send this stuff? That's what they told me.
And do you know what
I
time
wrote
you,
it down.
what time you sent that email?
This, the one from Lorna Croft was just sent to you all just before y'all called my case. It was just, and I do have the case number written on top of it. At 49D22-2209 IF-033189. Now, I don't know whether I wrote the case number. I know I put it was from me. I can't remember if I put the case number because it was sent about a month or so ago.
I suppose let
In
me
December.
let me ask the parties this. Obviously, as far as doing remote hearings, one of the things we have to ensure is that everybody has an opportunity to present their evidence in order for this to be done in accordance with the rules. Sounds like she attempted to potentially submit some evidence and was maybe given information for the prosecutor's office, which of course you guys need to be able to see anything she might file anyways, instead of to the court. And right now it would appear we're having some difficulty potentially allowing her to lay a foundation to potentially admit some exhibits into evidence. It sounds like she lives in Tennessee, so I don't believe she's looking to come in person. But if we're not able to get these things pulled up, would it be the preference of the parties to potentially bifurcate this to allow her time to send the information to the courts and the state so that that way we can come back for a future hearing date and she can make her attempts to admit potential exhibits into evidence? Does that make sense what I'm saying?
Yes, Judge.
At this point, Mr. Niekamp, would that be the state's preference? Again, I don't think there's much left as far as testimony. I think it's just whether or not she can lay the foundation for the exhibits. But it sounds like you haven't seen them yet and court hasn't seen them yet. And it sounds like one at least she sent a month ago and then the other one sent more recently.
The state has no problem with bifurcating.
Okay.
You
So,
naughty
ma'am, let me
boy.
explain what, because that was kind of maybe too legal jargony, if you will. So to put it into more lay terms, there are some documents it would appear that you're wanting to admit into evidence for the court to consider. And right now, the court doesn't have those documents. And it would appear the state is also having some trouble locating those documents. And so the court wants to make sure you have a chance to present your whole case. And if those documents are a part of that, want to give you an opportunity to try to move them into evidence. It's no guarantee they'll be admitted into evidence, but at least court needs to give you that opportunity. So what I'd like to do at this point is make sure that you get all the information you need to ensure a copy is provided to the state, as well as a copy provided to the court. So that way, when we come back the next time, everybody knows what specific documents it is that you're talking about. And again, you can try to move those documents into evidence because right now they are not a part of evidence. Do you understand, ma'am?
Yeah.
No, she doesn't. But I'll explain it in more simple terms. The judge and the prosecutor want to bifurcate, sort of like a menage a trois with you, ma'am.
I do, but you got to realize you got somebody that's really stupid when it comes to emailing and stuff like that. It said it went, but it could be on my end, but I can resubmit them. Some I have in my phone. Some I got printed off from the DMV where it shows where I was medically certified on the 16th. So
Sure.
Either medically certified as an MD or medically certified as insane.
So any documents
I
that
don't
you
know what else. Can I
Yeah.
mail it? Could
you
I mail
should
it
be able
instead?
to receive it via the email, but certainly you're free to use other forms of relaying those documents. But what we'll do is make sure you have the correct email address for the court, and then make sure you have the correct email address for the state. We'll also give you the phone number for the court, and then reset this for a new date. We're not starting over from scratch. The court's just going to bifurcate the trial today to allow that process to play itself out.
We already did the floor play, ma'am, and I'm not going to do it again.
And
Okay.
and then we'll just pick up from where we are, which is you're still basically presenting your evidence. You've already testified, but it sounds like you're trying to admit some documents into evidence, and those are the ones that Mr. Niekamp would need to be able to review, and then the court would also need to receive, so that way, again, everybody
So
can make sure we're talking about the same documents.
I got a question.
Yes, ma'am.
Now, if you're not notified for the state that they've done something with your license, I
Well, ma'am,
mean,
I
what
can't
am
get
I supposed to
into
do about
the
that?
legal issues today as far as the court issuing its rulings and its findings. after all the evidence is admitted, then each party is going to be free to argue what the court should find as far as if your argument is that you did everything you needed to do and it was the state of Tennessee's fault for not correctly updating and you shouldn't be held liable versus it doesn't matter if it was the state of Tennessee's problem. At the moment you were in Indiana, you didn't have a valid CDL. I'm going to let the parties argue the law as it relates to that particular issue. And it's not my role to be able to provide you with legal advice. So that's not something that I'm permitted to do. So when we come back, it will be for the purpose of you being able to continue with your presentation, which at this point sounds like it's mainly making sure we get documents to the state and to the court that you're wanting to admit. If there's other evidence you wish to present, you're also going to be free to do that at the next hearing date, and then we can see if the state has any rebuttal evidence, and then both sides can argue the law at that point. So that's what we're going to do, is continue the trial to a new date. Again, we're not starting over, we're just bifurcating it for a new
Okay.
date to allow that process to play out. So make sure you have a pen and paper handy right now. I'm going to give the state a chance to give you the correct address for those docs to be sent to, which I think you've already got. But we'll just confirm that up. And when you send it, send everything again. And then we'll also give you the address for the court as well to send those to. Okay?
Okay.
All right. So Mr. Niekamp or Ms. Walker, if you want to go ahead and give that email address for the state.
Judge, can we just give her the court's email address and the court
Okay.
forward it to me? So that way there's one email she has. It doesn't sound like she's able to take down multiple email addresses. So I think if we just did one email address and the court provided a copy to me, that would be sufficient.
All right. So we'll note state is okay with.
Okay, but there's only one problem with this plan, guys. There were two email addresses that they had at their disposal, and they picked the hardest one to, to give to this lady. And we're going to see her try and get it.
Just having it sent to the court and then the court forwarding that along once received. And so, Lily, if you want to give our email address and then our phone number so we can make sure that we get everything that she's trying to have the court consider.
Ma'am, are you ready to write it down?
Yes, ma'am.
It's MCOURTS. So M Courts.
Courts.
M Courts hyphen MAG
MAG.
hyphen IFOV
F. So V as in Victor.
yes
Okay.
at indy.gov.
Okay, I got it. Let me read this again. M Court hyphen
Courts with an
MAG.
S.
Courts with an S. I'm sorry. Hyphen MAG IFOV at indy.gov. Is that all lowercase or uppercase, or does it matter?
Mix
It
it.
doesn't matter, but there's a hyphen between the G and the I.
Yes, I got it. I got the hyphen.
All
Okay,
right. We're
I got it.
also going to give you our phone number in case you make some attempts and it doesn't appear to go through. Okay.
Okay.
317-327-5418.
418. 317-327-5418. Okay, got it. Thank you.
All right. And then the last thing we're going to do is we're going to pick a new date for everybody to come back on to pick up the trial from where we've left off. Mr. Niekamp, did the state have a position as far as time frame when we'd want to reschedule this?
How much time is she requiring?
Ma'am, how long do you think it's going to take you to get everything collected and then sent to the courts and for you to be ready to go?
I'll have to find it. It won't take long. I'll send it. I'll get to looking for it tonight. I think I filed it away in my file cabinet, some of it, and then some of it is on my phone already. So
All right, so
where I
no more than a couple days or should be in the next couple weeks, you'd be able to get everything sent and ready to go. Is that fair to say?
yes.
Okay, all right, so it doesn't need to be set out too far. So with that in mind, Mr. Niekamp, what's state's position?
Officer Yanisevich, do you have any unavailability in the next 2 weeks?
Let me look, check my calendar.
Of course, everybody's ready to bifurcate together, and the police are stopping them. He has to check his calendar.
And if she's trying to establish her license status now, I actually reviewed it before trial. I can testify that if that helps.
It's okay. Thank you, though. I think we're just gonna wait till she has a chance to send her exhibits. But if you've got availability in the next couple of weeks,
Looks like I believe there's a lot of colors on my calendar here. I'm sorry, I'm getting used to this. Looks like I'm good to go until the end of this month.
okay. So long as it was before the end of the month, you're good.
Yes.
Okay.
All right, so Lily, is there a date that's looking better than others during February that we can put this on the afternoon calendar?
We can do February 29th at 1:30.
Would that work for you, Mr. Niekamp?
I would defer to Officer Yanisevich.
Officer
I'm fine with that.
Yanisevich?
Okay, that works for us.
And ma'am, would it work for you to come back on February the 29th at 1:30?
Yes, I'll be fine.
All right, so we'll go ahead and again reset this for February the 29th at 1:30. Again, we're not starting from scratch, just to be clear, everybody. We're just going to be picking up from where we left off, which is primarily focused on making sure these documents are sent to the court and then forwarded on to the state. And then, ma'am, it'll be up to you to try to get those admitted into evidence, okay?
Okay.
All right. Anything else from the states in Mr. Niekamp?
Deadline February 14th for receipt of any documents she intends to introduce. Otherwise, if they're not received past February 14th, they're not going to be admitted.
So what the state is requesting at this time, ma'am, is that the documents be submitted to the court by February the 14th, which is effectively a week away, in order for those to be considered in evidence. And so you do want, and I think that's a fair request. So that is what the court will order, which is if you want those documents to be potentially admitted into evidence, because again, I'm not saying they will be admitted, only I'm going to give you the chance to attempt to admit them. Need to make sure that you get those sent out by February the 14th. So do call the court to confirm again that they've been received sooner rather than later, so you're not at risk of having those not being able to be admitted. Understand, ma'am?
Yes, sir. I'll work on it today.
All right, thank you very much. And Officer Yanisevich, certainly appreciate your patience and understanding as we work through these particular issues. But thank you for being here this afternoon, sir.
No problem. I know these are all complicated. Thank you.
Thank you, sir. And Ms. Sawyer, unless you have any questions, you are also free to log off at this time. We'll see you back here on that February date we provided. But remember, make sure that you get any exhibits that you wish to potentially admit into evidence to the court by Valentine's Day. All right?
Okay. Here you'll have it. I thought you already did.
You do not, ma'am. We do not. So we're going to try to make sure you have that opportunity. If you have no questions, you're free to log off. Have a great day, ma'am.
All right, you too. Thank you.
You're so welcome. Bye-bye.
Thank you, Your Honor.
Thank you, Officer Yanisevich.
Okay, now I have to ask. Who here thinks she wrote that email address down correctly? There's no way. She's going to end up, you know what? She's going to mess it up so bad that she's probably going to send it to the prosecutor instead. Oh, man. Okay. let's go to Indiana and let's just watch a judge enjoying his job.
State of Indiana versus Joseph Akers, 20E029504CM337. Sir, what is your name?
Joseph Akers,
What is your date of birth?
11/20/1970.
What is your mailing address, including city, state, and zip code?
P.O. Box 67, Sandusky, Ohio 44871.
Were you transported here from Ohio, or?
I was passing through and I was pulled over for a bench warrant or a warrant. My understanding is it's like 20-something years ago.
And I'm going to tell you about it. I was just curious where and how you got arrested. Where were you arrested on this? In this county or somewhere else?
LaGrange County, I believe it was.
When were you arrested?
Friday, last Friday.
But you didn't get any new charges in LaGrange County, did you?
No.
So you were arrested last Friday the 2nd, and then we came and got you and brought you here.
Yeah.
Is that right? Okay. Did you hear and understand the rights I just explained to you?
Yes.
Okay, you're right. This is an old charge. I'm going to have the officer give it to you. I'll read it to you. Back on let's see. Back on April 28th of 1995, the state of Indiana charged you with battery as a Class A misdemeanor. Omitting formal parts, it alleges that on February 25th of 1995, the county of Elkhart, state of Indiana, one Joseph Adam Akers did then and there knowingly touch one David C. Dickel, a human being, in a rude, insolent, or angry manner. To wit, Joseph Adam Akers was at the Winner's Circle. I don't know what that is. The Winner's Circle in Middlebury with his brother Daniel Lee Akers. Daniel was asked to leave, so Joseph Adam Akers was going to leave too. Just before Joseph got out the door of the bar, he had a pool ball and threw it, and they misspelled threw, striking David C. Dickel on the head. If you're found guilty, you're facing up to 1 year of incarceration and up to a $5,000 fine.
Oh, wow.
He's laughing at him and he says,
Yeah,
oh,
okay,
wow.
well, I'm going to enter a preliminary plea of not guilty, which will become a formal plea of not guilty in 10 days. Now, do you have first of all, do you have the ability to hire a lawyer?
No.
Do you work?
I'm on disability.
Is that your only source of income, disability? Do you have any money saved at all?
No.
Do you have a bank account?
Yeah.
Excuse me. What's the current balance of the bank account?
Probably less than $200.
Do you have any money on your books here?
I think I have about $80 in cash, and then I have my bank card, which is about close to $200 on that bank card.
And it's in your property here?
Yes.
I assume the cash was in your wallet?
Yes.
How much cash exactly is in your wallet, if you know?
I'm not for sure, but I think it's like $80.
Do you think it could be less?
It's possible, but I doubt it.
Do you think it could be more?
I think I used $20 on a toll road. I had $100 in cash, but I used $20 on the toll road.
Exactly 20?
A little less than 20.
So then you have at least $80.
Yeah.
Okay. There's a reason I'm asking all this. First of all, I'm going to find that you're indigent, and I'm going to appoint you the public defender's office. I'm going to appoint you a lawyer. Okay.
Okay.
And all of you today, by the way, you're going to be given paperwork before you leave the courtroom. Don't lose that paperwork. It has your future court dates on it, and it also will have the address of the courthouse on it. Actually, by coincidence, all of you today, all your cases are in the same court. So we have 6 courthouses in this county. All of your cases are in Superior Court 4, filed in the courthouse. That's in the courthouse on Main Street in downtown Goshen, Indiana. Okay? So don't lose the paperwork we give you.
Okay.
I need to set a future court date that you must attend. It's a combined omnibus and further proceedings date, March 19th, 2024 at 9 in the morning. You got to be in court then, you understand?
Yeah.
Oh, okay. And then, are you on any sort of probation or parole or anything in Ohio?
No.
What was this date of birth?
11/20/70.
Of 70? The warrant the bond on the warrant right now is set at, I got some of the stuff's turned sideways, so it's kind of, I look kind of dumb here, but I always look dumb. It was a failure to appear warrant. You had a summons that was issued to you. Did you used to live in Middlebury, 53407 County Road 39?
I've never lived in Indiana. I'm off from Ohio.
It's odd.
This whole thing that I'm reading, that I was just reading here, it does have my brother's name on it. But I don't know anything about this incident. You know, when I came to court this morning, I was thinking that I would see if I can just try and diminish this today until you told me I'm looking at a year in incarceration.
Well, yeah, you got
I
to
have
go
a
to.
lot of medical issues, and there's
Right.
no way I could do something like that.
No, I understand. You got to go to your next court date. But here's what I'm going to do, Mr. Akers. I mean, the bond is already, it's set at $1,000, which 10% cash is only $100. You've got $80 in cash here. Here's what I'll do. I don't know you. I don't know your history. I can't look you up. I can only look people up in Indiana. I'll reduce your bond. I'm just going to set the bond at $80 cash. You can bond yourself out today with the cash in your wallet.
Okay.
And if there's anything that the officer can do to make sure that he gets some assistance in getting the cash out, or he can use his debit card or credit card. But.
Okay, $80 minus $4 for the fee we charge here, so it's gonna have 76 paragraph.
So if it's just $80 cash, it's not 10%.
No, I'm saying is we charge this person $4 for the hygiene, so the is less than $80. You're gonna have less than 80.
Oh.
So,
There's a
so you know, so that's how it works.
$4 fee? I guess.
Yeah, for the hygiene kit that we charge, so $4 for each person that moves down to the pod, we charge $4 for the hygiene kit.
Okay, how about $75? $75 cash.
Yes, sir, that should be.
I feel like I'm bartering with the corrections officer.
You know.
No, I didn't know that anyway. I
Would you
didn't
like to represent me, sir?
He's
He seems to be doing pretty good for me.
Yes.
Well, he doesn't want to yell all the time, and neither do I. And here I. Okay, $75 cash. I'm going to set the bond at $75 cash.
Okay.
You got that money in your property, so you can bond out today.
Okay.
But do not miss court. You got to go to your court date.
Definitely.
March 19th at 9. Finally, we're giving you the public defender's contact information in writing. You got to call him when you get out of jail. You can do it next week. But get
Okay.
yourself out of here. Okay?
Okay.
Go back and Sandusky, Cedar Point.
Well, I have to come back here, so.
Well, you're allowed under the law to go back to Ohio, but you got to come back for your court date.
Okay.
Okay.
All righty, so.
Good luck to you.
Thank you, sir.
You're welcome. Okay.
Just a judge enjoying his job. So, you know what? Let's stick with him.
10. Sir, what is your name?
Daniel Ray Rose,
What's your date of birth?
4/9/1988,
What's your mailing address, including city, state, and zip code?
54512 Ash Road, lot number 368, Osceola, Indiana, 46561.
Thank you. Did you hear and understand the rights I just told you? I can't hear you.
Yes, I did.
Okay. I'm going to have the officer give you a copy of the 3-count charging information that was filed by the state of Indiana on February 2nd of 2024. Count 1 charges you with level 4 felony unlawful possession of a firearm by a serious violent felon. Omitting formal parts, count 1 alleges that on January 30th of 2024 at the County of Elkhart, state of Indiana, when Daniel R. Rose, a serious violent felon, knowingly possessed a firearm, to wit, a shotgun, after having been convicted of a serious violent felony, to wit, dealing in methamphetamine, on or about May 20th, 2010, in the Elkhart Superior Court 3, cause number 20D030905 FB27, in Elkhart County, Indiana. Count 2 charges you with level 6 felony identity deception. It alleges that on the same day you did, with the intent to defraud or harm another person, to it Dustin Hardy, knowingly obtain, possess, transfer, or use identifying information to profess to be another person. Count 3, possession of paraphernalia, a Class C misdemeanor, alleges that on the same day you did knowingly possess a raw material, an instrument, a device, or other object that you intended to use for introducing into your body a controlled substance. Count 1, if you're convicted, the minimum sentence you're facing is 2 years. The maximum sentence is 12 years, and you could be fined up to $10,000. Count 2, the minimum sentence you're facing is 6 months. The maximum sentence is 2.5 years, and you could be fined up to $10,000. And then count 3, you're facing up to 60 days of incarceration and up to a $500 fine. I'm going to enter a preliminary plea of not guilty, which will become a formal plea of not guilty in 20 days. Are you able to obtain an attorney if I give you some time?
I just talked to you on Tuesday and you told me to save my questions for today on this case.
Oh, okay. That sounds
because
like
you
me.
said you would have more information on this.
Yeah. Oh, I remember you now.
I just picked up my fiance from the Greyhound bus station. She loaded her bag in the back.
Okay.
I did not know that was in there,
Yep.
or she would not got in there with it.
Let me
She
see.
just came from Biloxi, Mississippi. She brought it with her. I did not know it was in there.
Hold on. I know exactly where you're going. This comes up a lot. I'm going to look at the probable cause affidavit. Give me a second. I'm also going to print it for you. The best thing that I can surmise here is that because it's alleged that this was the result of a traffic stop and the the passenger cabin of a car is a very small area, and it's alleged that there was more than one person in the vehicle. It appears, but your lawyer will be able to tell you for sure because your lawyer is going to get all the discovery. This is just preliminary. It appears that they're alleging possession because it was so close to you in the vehicle. Now, in Indiana, I understand that. I understand that. But you gotta listen to me, Mr. Rose. I'm gonna try to explain it to you.
I'm listening, sir, but
But you're not listening because when I try to explain it, you're just getting angry and then you interrupt me, and that's what you did last time. And you don't want to hear anything that I have to say. So I'm just gonna shut up. I'm gonna appoint you the public defender's office as I did just a few days ago, and schedule the following court dates, which are in Superior Court 3 in the courthouse in Goshen. And they are as follows. Your omnibus date is March 28th, 2024. Your plea bargain deadline is April 4th, 2024 at 9 in the morning. Your pretrial conference is April 18th, 2024 at 9 in the morning. And your jury trial, if this goes to trial, I'm going to schedule that for April 29th, 2024 at 9 in the morning. Do you understand and acknowledge I just scheduled your jury trial for April 29th, 2024 at 9 in the morning in Superior Court 3 in Goshen?
yes, sir.
If you fail to appear for that trial, the trial can go forward in your absence, the jury could convict you in your absence, and a warrant could be issued for your arrest. Do you understand that?
Yes, sir.
Well, so the defendant acknowledges his jury trial in open court.
Yes, sir.
Do you know who your public defender is yet?
No, sir.
Christopher Crawford. She's going to write the name down for you.
Can I ask you a question, sir?
Yes, if you let me answer it.
I apologize.
Ask the question.
Can you finish telling me what you was going to say before?
I would love to if you listen. Are you going to be quiet and listen? It is alleged that when they pulled the vehicle over, there was a loaded shotgun with one in the chamber and 3 cartridges found in the back seat on the floor. And then they go on to talk about some identification cards that they found, et cetera, et cetera. It is alleged that they spoke to Miss Overstreet, and it says Overstreet also claimed ownership of the shotgun. And then that's all with respect to a gun. That's why what I was saying is, it appears to me that they are charging you with it under the legal definition. It's called constructive possession. So a couple of things to remember, Mr. Rose, because if I were in your seat, in your shoes right now, I would probably be thinking and feeling the same way you are, if what you're saying is true. This is just an allegation at this point. You have every right to take this to trial and fight it. No one has said that you are guilty. You are innocent unless or until you're proven guilty. But the state has to prove possession, not ownership. There could be an element of knowledge. I understand exactly what you're saying when you say, I had no idea that there was a gun. And that may end up saving the day, and then this case may resolve itself in such a manner that you're not convicted in count one. But under Indiana law, more than one person can possess something, particularly in a small area. So I see every day in my job when a vehicle is pulled over, let's say there are 5 people in the car, and this is just an example, and there's a bag of marijuana in the center console, all 5 people get charged. Because the state does not have to prove ownership ever. There is no crime in Indiana about ownership. It's all about possession. And in Indiana, under our law, a person can possess something even though it's not on their person. If I live alone in my house and I'm standing in my bathroom combing my hair, I'm actually possessing my toothbrush that's on the counter right in front of me. I have the ability to maintain dominion and control over it. It's near me. It's not on my person. But the reason why the law says that the state only has to prove possession, and the reason why we have a legal concept in Indiana, and most states have it called the concept of constructive possession, is because if we didn't, then no person could ever be convicted of having something illegal near them. Someone could say, I have 10 pounds of meth under my bed, but you can't get me because it's not on my person. It's under that theory that they're presumably charging you because it was so close to you in a small passenger cabin. But that does not mean you're going to be convicted, okay? So I'm going to give you the probable cause affidavit, and you can read it, and then I want you to talk to your lawyer about it, okay? All right. So I got you court dates. You confirmed your trial. I'm going to have, and then your bond on this case is set at $10,000. However, I don't remember. Did I tell you you had no bond on the violation? I'm assuming.
Can I get a bond on the violation, sir?
Let me see. So she did issue a no bond warrant. And so Christopher Crawford will very likely file a motion for a bond report, and you will very likely have a bond hearing. So you need to talk to Mr. Crawford about that. The bond on today's case is $10,000, but even if you had it, don't post it right now because you're without bond on the violation.
My father's probably gonna die within 3 hours. You can call
Huh?
there's no way I can get a bond for an hour, turn myself in. I don't know.
No, that's not how it works.
For a furlough or something, I don't know. I don't know how that works. I've never.
For what?
My father's about to die within the next few hours. I just was told that before I got here.
So here's how that
I don't know what else to ask. I don't know.
No, I would ask the same thing. So we're giving you the contact information for the public defender's office. Your lawyer is Christopher Crawford. If there's a furlough that's requested, he can file it for you. They do that all the time.
He was my lawyer last time, and it took me 2 months to get a hold of him. I appreciate it.
Well, I still got to have you fill out your contact information though on one of the date sheets.
Same as the ones I just put out Tuesday.
Don't. Okay, State of Indiana versus Bradley Novak, 20.
He stopped there and just went on to the next person. That was it. It got sad at the end. I'm sorry about that. But yeah, I don't know. I just know that if I'm gonna get arrested, I'm gonna do it in Washington. And I just absolutely am not going to get arrested in Indiana. If I can, I will drive around Indiana because I hear all these cases and these judges are harsh. They don't not play around. All right, one more from this guy. One more.
FD 57. Sir, what is your name?
John Newell.
What's your date of birth?
4/13 of 83.
What is your mailing address, including city, state, and zip code?
Five three.
That's fine. Did you say County Road M as in Mary?
Mm-hmm.
It's just the letter. Okay, did you hear and understand the rights that I explained?
Yes, sir.
Okay, I'm going to have the officer give you a copy of this charge. It was filed quite some time ago.
That is something I would like to inquire about.
Okay, hold on one moment. I just gave it.
Yeah, it's not in in Odyssey, we had to request it.
Oh, I didn't know that. I need that back. I can't see it in the computer. I'll give it back to you in a moment.
I was trying to catch you before you.
Oh, that's all right. So on January 14th, 2023, I said that wrong. I'm so sorry. January 14th, 2013, the state of Indiana charged you in this case with one count of Class D felony escape. Omitting formal parts, it alleges, that on October 22nd of 2012, at the County of Elkhart, State of Indiana, one John D. Newell did knowingly fail to return to lawful detention following temporary leave granted for a specific purpose or limited period. It is a Class D felony. If you are convicted, the minimum sentence that you're facing is 6 months. The maximum sentence is 3 years, and you could be fined up to $10,000. I'm going to enter a preliminary plea of not guilty, which will become a formal plea of not guilty in 20 days. Now, you said you had a question. I don't know if I can answer it, but I'll try.
Okay, so 2 questions. Am I not past the statute of limitations for this charge? The state knew exactly where I was for the entire time. They did not come and get me. I was incarcerated in Wisconsin. They did not come and get me.
Hold that thought. Statute of limitations is what governs the time frame within which a case can be filed. On a Class D felony, which now that's level 6, it's 5 years. The statute of limitations in this case means that the state would have to file a charge within 5 years of the alleged offense, and they filed it in 2013. The alleged offense occurred in 2012. So the statute of limitations was not violated.
Okay.
But if instead you're talking about, there's a separate body of law that talks about a person's right to have a speedy and timely trial, and you might be talking about, and I'm going to tell you, you need to talk to your lawyer about it, if what you're talking about is not necessarily statute of limitations, in other words, not necessarily the date they filed the charge, but if you're talking about they filed the charge and it's your belief, I don't know if you're right or not, but if it's true that the state knew exactly where I was and they did nothing to get me and bring me here and bring me to trial, there's a body of law that governs that based in case law, and you must talk to your lawyer about it.
Okay.
Okay?
Second is, so am I going underneath the old law or am I going underneath the new law for this case?
What do you mean new or old?
So
what law?
when this case was
Are you talking about credit time? Yeah, it's the old law, but even today it would be a level 6, which is still day for day. If you're talking about do I do 50% of my sentence if I'm convicted? The answer is yes. Half of whatever the sentence is. And it would be that way today too. Did I answer your questions?
Yep.
Okay, then I'm gonna, I already told you I'm gonna play not good. Can you afford to hire a lawyer?
No, sir.
Do you have any money saved?
No, sir.
Do you have a bank account?
No, sir.
Do you have anybody who could help you hire a lawyer?
No, sir.
Were you transported here from some other jail or prison?
No.
Were you arrested in Indiana on this warrant?
No, I turned myself in.
You came here and turned yourself in? Okay. Well, but you have no money saved or put away? Okay, then I'm going to appoint you an attorney from the public defender's office. I'm also going to order on my own, I'm going to order a bond report because the bond it's a lot. It's $50,000, surety only. So I'm going to order a bond report and get you in for a hearing to see if the court's willing, after hearing arguments, to reduce your bond. I assume you want me to do that.
Yes, sir.
Then I'll do that. So your bond hearing is at the very latest, March 11th, 2024 at 11 in the morning. If they file the bond report before that, it may be before March 11th, but tentatively March 11th. Your attorney conference is March 20th of 2024 at 1 in the afternoon. Your omnibus date is March 25th, 2024, and then your plea bargain hearing is May 6th, 2024 at 8:30 in the morning. Someone from the public defender's office will be in touch with you soon here in the jail, as well as someone from the probation department for that bond report. In the meantime, I recognize it's a lot of money, but you do have a bond on this. So in the meantime, to bond out, it would be $50,000 as of right now, which would be.
That doesn't drop down to 5?
It does, yeah. I was going to say that. So it would be about $5,000 or maybe a little less to a bondsman, because it's a surety warrant. I would also be. I'm okay doing a 10% cash option too. That's what Superior Court 1 does now. So please put in the notes, bond maybe 10% cash or surety. What that means is, the other way to bond out is if you or someone on your behalf paid the jail $5,000 cash, credit, or debit, you'd be released. The court holds on to that $5,000, and when your case is resolved, we'll give almost all of it back to whoever posted it. But if you can't come up with that money, you're gonna have
If
that
I'm
bond
charged
hearing.
guilty or not guilty, they would still get the money back?
Right.
Is that
Yep.
what you're saying?
Yes. Yep. If you're convicted, we'll deduct fines and costs from it. But on something like this, it'd be a few $100s. I mean, they would get almost all of it back.
And you said with this charge, I do day for day?
Right.
So
If you're convicted, you're not convicted. So let's say you were convicted, for example, and let's say you were sentenced to 1 year of jail, you would do 6 months.
So it's
Half.
2 for 1?
Yes.
Okay.
Absolutely.
Okay.
All right? And then there's a copy of the charge. And then if you do bond out, be sure you get a hold of the public defender's office. We're giving you their contact information.
Now this is active right now. If somebody came up here right now with $5,000, I could leave.
Yes. And then it gets sent to the clerk's office and the court holds on to it.
Okay.
Or you can go through a bondsman, but you will never get any of that money back.
That's fine.
But just don't miss any of your court dates if you bond out, okay? Good luck to you.
I didn't come all the way back to Indiana and turn myself in to run again.
I understand. I appreciate you turning yourself in.
Have a good day.
You too. State versus Kevin Johnson, 20D01.
Well, guys, we had a day. The chat is getting into geography, so that leaves me out. But the chat is always just as funny as the videos. They're just great. Y'all are great. Seriously. Thank you so much for coming out tonight, where we stirred the pot tonight, and I can't wait to see some of the comments I get tomorrow. I'm gonna get killed. Oh my. Guys, thanks for coming out. I will try to get more for tomorrow, but I work another double, so it's getting hard. But I hope you have a good weekend if I don't get to talk to you tomorrow. Lightfoot, I hope you have a great day. Or night, I don't know, it's New Zealand. Whatever you're in, day or night, I hope it's great. Mike, thanks for coming in. All right, guys. See you next time. Bye.